A black lawyer calmly endures a judge's arrogant lecture until she drops a truth bomb that silences the entire courtroom. I trained you in law school. Power shifts instantly. Dr. Maya Richardson adjusted her glasses and straightened her charcoal suit as she entered courtroom 16 of the Metropolitan Courthouse. At 45, with 15 years as a Harvard law professor, 12 published legal texts, and a reputation as one of the nation's foremost constitutional scholars, she usually commanded respect wherever she went. Today, however, she felt the subtle resistance that often greeted her in spaces like this. Her client, Marcus Wells, sat beside her, his shoulders hunched under his borrowed suit. The struggling community organizer's civil rights case against Meridian Enterprises represented everything Maya had dedicated her career to: justice for those without power or privilege. The opposing counsel, 3 white men with identical haircuts, from the firm of Bradshaw and Sterling, were already seated, arranging their documents with confident familiarity. Maya noted how the bailiff had greeted them by name while barely acknowledging her presence. "All rise for the Honorable Judge William Harrington," announced the clerk. The judge entered, a stern figure in his late 50s with silver-streaked hair and a reputation for traditional interpretations of the law. As he settled into his chair, Maya studied his face, feeling an odd sense of recognition she couldn't place. Something in his demeanor, perhaps the way his eyes narrowed slightly when they rested on her, suggested this would not be an easy hearing. Throughout the preliminary proceedings, Judge Harrington addressed the corporate attorneys as Mr. Pearson and Mr. Walsh, while referring to Maya only as counsel for the plaintiff. When the defense fumbled a procedural question, the judge offered guidance. When Maya requested clarification on a filing deadline, his response dripped with impatience. Still, Maya rose with practiced composure when called for her opening statement. "Your Honor," she began, "today we bring before this court a case that exemplifies—" "Counsel," Judge Harrington interrupted sharply, "I suggest you stick to the facts, rather than attempting to educate this court on matters of justice. We're quite familiar with the concept." By the 3rd day of trial, the pattern had become unmistakable. Judge Harrington sustained objections from Meridian's attorneys before they'd finished speaking, while Maya had to articulate every basis for her objections in exhaustive detail, only to have most overruled with a dismissive wave. "Your Honor, I'd like to enter these employee records as Exhibit D," Maya said, approaching the bench with documents meticulously organized in a labeled folder. "Counsel, have these been properly authenticated?" Judge Harrington's tone carried the weariness of addressing a first-year law student rather than a Harvard professor. "Yes, Your Honor. As indicated in our pre-trial submissions, page 27, section 4. "Very well," he cut her off, while gesturing for the clerk to take the documents. Minutes later, when opposing counsel Ryan Walsh submitted evidence, without authentication references, the judge accepted them without question. Maya maintained her professional demeanor, her face a practiced mask of calm detachment. She'd long ago perfected this expression, during her first year at Harvard Law, when a professor had suggested she was an affirmative action experiment, during partner meetings at her previous firm, when her ideas were ignored until repeated by male colleagues, and during countless courtroom experiences, where she had to be twice as prepared and half as emotional as her white counterparts. "Permission to approach the witness, Your Honor," Maya requested during cross-examination. Briefly, "Counsel, the court's time is valuable," Judge Harrington replied, checking his watch pointedly. Zoe Martinez, Maya's paralegal, sat behind the plaintiff's table, her pen pressing so hard against her legal pad that the tip broke. 26, brilliant, and in her 2nd year of law school at night, Zoe had been watching the proceedings with increasing indignation. During the recess, she cornered Maya in the hallway. "Dr. Richardson, this is blatant discrimination," Zoe whispered fiercely. "The judge has interrupted you 17 times today. I've been counting, while Walsh and Pearson practically get applauded for clearing their throats." Maya steered her toward a quiet corner. "I know, Zoe. I see it too. We should file a complaint. I've documented every instance." Maya's gaze drifted to her client, Marcus, who was nervously adjusting his tie near the water fountain. "And what happens to Marcus's case if we do?" "Judge Harrington won't recuse himself based on microaggressions he'll deny existed, and then we'll have an openly hostile judge instead of a subtly biased one." The internal battle had been raging since day one. Address the bias directly and risk her client's case, or navigate around it to secure the best outcome possible. Every condescending Ms. Richardson instead of Dr. Richardson, while the male attorneys were addressed by their proper titles. Every interruption, every dismissive glance added weight to a burden she had carried her entire career. During the afternoon session, Walsh approached her table during a sidebar, leaning too close. As he reached for a law book, "Impressive argument this morning, Maya," he said with a familiarity he hadn't earned. "Pretty passionate. You might want to dial it back, though. Judge doesn't respond well to emotional women." Maya met his gaze with steel in her eyes. "Thank you for your concern, Mr. Walsh. And thank you for confirming you found my completely professional presentation emotional. I'll be sure to note that in my records." Walsh retreated, his smile faltering, but Maya knew these small victories came at a cost. Each confrontation, each moment spent managing discrimination, was energy diverted from her client's needs. At 2:13 a.m., Maya stared at her laptop screen. In her hotel room, surrounded by case files and empty coffee cups. Tomorrow's witness, a former Meridian executive with crucial testimony about discriminatory practices, would face brutal cross-examination. She needed to anticipate every attack, prepare for every contingency. Her phone rang, displaying Dr. Eleanor Washington. Maya answered, grateful for her mentor's sixth sense about when she was struggling. "You should be sleeping," Eleanor said without preamble, her voice carrying the weight of 40 years in legal practice. "So should you," Maya replied, rubbing her eyes. "I saw the trial coverage. Harrington's showing his colors." Maya sighed, letting her guard down for the first time in days. "It's like law school all over again. Everything I do is scrutinized. Every argument needs to be perfect." Walsh could stumble through his questioning like a first-year associate and still get preferential treatment. "Remember what I told you when you were denied that clerkship despite having the highest grades in your class?" Eleanor asked. Maya smiled, faintly. "That I'd have to be twice as good to get half as far. And what else? That being twice as good was never going to be a problem for me." "Exactly," Eleanor affirmed. "Maya, you've navigated hostile environments your entire career. This isn't just about Marcus's case, though that's priority one. It's about every young attorney of color watching you now, learning how to maintain dignity and excellence even when the system is stacked against them." After they hung up, Maya stood by the window, looking out at the city lights. Every slight from Judge Harrington echoed previous battles. The law review editor who lost her submissions, the clients who requested someone else when meeting her for the first time, the security guards who stopped her in courthouse hallways, assuming she was a defendant rather than an attorney. The cumulative weight of these experiences pressed down on her shoulders as she prepared for tomorrow. She thought about Zoe, watching her navigate these challenges, learning from her responses. She thought about Marcus, whose future depended on her ability to overcome these obstacles. She thought about the aspiring attorneys who might face Judge Harringtons of their own someday. Maya returned to her desk and opened a fresh document. She began mapping out a new strategy for tomorrow's examination. If direct confrontation about bias would jeopardize her client's case, she would find another way. She would document everything meticulously. She would anticipate the judge's interruptions and build them into her questioning rhythm. She would prepare alternate routes to admitting key evidence. Most importantly, she would maintain the unflappable professionalism that had become both her armor and her trademark. She would not give Judge Harrington any ammunition that could be used against her client. Each microaggression would be noted, each disparate treatment documented, but her focus would remain on the case. As she finally prepared for a few hours of sleep, Maya reorganized her trial binder, creating a section labeled Post-Trial Matters. Whatever the outcome for Marcus, she would ensure that Judge Harrington's conduct received appropriate scrutiny after her client's interests were fully protected. The courtroom fell silent as James Farrell, the former Meridian VP of Human Resources, took the stand. Maya had spent weeks securing his testimony about the company's discriminatory promotion practices. His evidence was crucial to Marcus's case. Maya approached with measured steps. Mr. Farrell, could you explain the promotion review process at Meridian Enterprises between 2018 and 2022? For 40 minutes, Maya guided Farrell through a methodical examination that revealed a pattern of systemic discrimination. She introduced internal memos, statistical analyses, and first-hand accounts that built an irrefutable case. Her questioning was precise, her logic airtight. Even the courtroom sketch artist had stopped drawing to listen. Maya was building toward her final point when Judge Harrington cleared his throat. Dr. Richardson, he interrupted, using her proper title for the first time, weaponizing it. I'm concerned about the direction of this examination. Maya paused, maintaining her composure. Your Honor, I'm establishing the pattern of what you're establishing, counsel, is a theatrical narrative rather than legal evidence. Judge Harrington's voice carried throughout the silent courtroom. In my 30 years of practice, I've observed that the most effective attorneys understand the difference between academic theorizing and practical jurisprudence. He leaned forward, his fingers steepled. Your aggressive questioning style and emotional appeals might impress students in a lecture hall, but in my courtroom, we adhere to standards of professional conduct. Your tone has been combative, your approach unnecessarily confrontational, and your demeanor lacks the collegiality expected in these proceedings. The courtroom tensed. A reporter scribbled furiously in the back row. Zoe's face had flushed with anger. Several jurors exchanged uncomfortable glances. Furthermore, the judge continued, constantly interrupting opposing counsel's objections suggests an inability to adhere to basic courtroom etiquette. This criticism was particularly galling. Maya had been the one repeatedly interrupted, not the other way around. While Harrington continued his lecture, Maya maintained perfect stillness, her mind racing through options. Challenge him now and risk prejudicing the jury? Document this clear abuse of judicial discretion for appeal? Focus on salvaging her examination? Perhaps at Harvard, theoretical legal constructs take precedence, but in this courtroom, something in his tone, in the particular emphasis on Harvard, triggered a memory. Maya studied his face more carefully, the slight asymmetry of his eyebrows, the way he emphasized certain syllables. And suddenly, she knew William Harrington. Front row, second seat from the left. Constitutional Law, fall semester, 2009. A student who had challenged every point she made, questioned her credentials repeatedly, and ultimately received a C+, despite his certainty he deserved an A. The student who had filed a formal complaint, alleging bias, which was dismissed after review. The student who had avoided eye contact during graduation, the realization almost made her miss the end of his lecture. So I expect more restraint in your approach going forward. You may continue. Your examination. Maya took a measured breath, her mind recalibrating. This wasn't just about unconscious bias anymore. This was personal. The knowledge shifted everything, and yet changed nothing about her immediate strategy. Her client still came first. "Thank you for your guidance, Your Honor," she replied, her voice steady. "Mr. Farrell, returning to the matter of the promotion review committees." As she continued her questioning, a new clarity guided her approach. Judge Harrington wasn't just any obstacle to overcome. He was one she had faced before, and if she had taught him once, perhaps she could teach him again. Maya stood perfectly still as Judge Harrington's lecture concluded. The courtroom hung. Intense silence, all eyes shifting between the judge's stern expression and Maya's composed demeanor. She allowed 3 measured seconds to pass, just enough time for his words to settle and for her to organize her thoughts. "Your Honor," Maya began, her voice clear and controlled, "I appreciate your guidance on courtroom decorum." She maintained direct eye contact, her posture straight but not rigid. "However, I must respectfully address several points you've raised." Maya gestured toward her exhibit binder. The questioning strategy employed with Mr. Farrell follows the precedent established in Thompson v. Westfield Corp., where Chief Justice Roberts emphasized that establishing systemic patterns requires methodical evidence presentation. She cited the page number and paragraph without consulting notes. "Regarding my tone, which Your Honor characterized as combative," Maya continued, "I've maintained the same measured cadence and volume throughout these proceedings. Court transcripts will confirm this consistency." Several jurors nodded imperceptibly. With each point, Maya dismantled the judge's criticisms using impeccable legal reasoning rather than defensive responses. She referenced the federal rules of civil procedure and relevant case law with precise citations, reminding everyone present that she wasn't just a practitioner of law, she was one of its foremost scholars. Furthermore, the suggestion that academic, legal constructs are somehow divorced from practical jurisprudence contradicts the very foundation of our legal system, Maya noted, her voice taking on the subtle cadence she used in her most popular Harvard lectures. As Justice Brandeis wrote, "Knowledge is essential to understanding, and understanding should precede judging." Something flickered across Judge Harrington's face, a shadow of recognition, quickly suppressed. The courtroom remained utterly silent as Maya reached the culmination of her response. "Your Honor," she said, her voice softening just enough to draw everyone closer, "I believe I should clarify something." She paused, her gaze steady. "I trained you in constitutional law at Harvard, class of 2009. You were a promising student with much to learn about judicial impartiality. That learning process, it seems, continues today." The words landed like a stone dropped in still water. First silence, then ripples of reaction spreading outward. A sharp intake of breath from the court reporter, widened eyes from opposing counsel. A hastily suppressed murmur from the gallery. Judge Harrington's expression transformed in stages. First confusion, then dawning recognition, followed by unmistakable embarrassment that flushed from his collar to his hairline. His hand, which had been poised to interrupt her again, slowly lowered to the bench. "I raise this not to embarrass the court," Maya continued into the stunned silence, but because transparency serves justice. Now, with your Honor's permission, I'd like to continue Mr. Farrell's examination regarding the documented disparities in Meridian's promotion practices. Judge Harrington's hands gripped the edge of the bench as he visibly struggled to regain his composure. His eyes darted briefly to the court reporter, the gallery, and back to Maya. "Proceed, Dr. Richardson," he said finally, his voice strained as he emphasized her proper title. Maya turned back to her witness with renewed confidence. "Mr. Farrell, you testified that minority employees at Meridian were required to meet additional cultural fit criteria not specified in the official promotion guidelines. Could you elaborate on how these unwritten standards were communicated?" As Farrell resumed his testimony, Maya subtly adjusted her questioning strategy. She incorporated phrases familiar to any student who had taken her constitutional law course: structural, inequities, substantive due process, disparate impact analysis, terms she knew Harrington had once struggled with on his midterm examination. The courtroom dynamics had shifted palpably. The opposing counsel's objections became less frequent and more carefully worded. The court clerk, who had previously avoided eye contact with Maya, now watched her with undisguised respect. Several jurors leaned forward, newly attentive to the evidence being presented. "Objection, Your Honor. Counsel is leading the witness," Walsh interrupted, during a particularly damaging line of questioning. Judge Harrington hesitated, his usual quick dismissal of Maya's arguments notably absent. "Dr. Richardson," he prompted. "Your Honor, I'm establishing foundation under Rule 611C, which permits leading questions when necessary to develop the witness's testimony, as we discussed in—" She caught herself before completing the reference to his time in her classroom. As established in Crawford v. Washington, this approach is appropriate when extracting specific factual details from a witness with specialized knowledge. Judge Harrington nodded slowly. "Objection overruled. The witness will answer the question." This small victory resonated beyond the immediate exchange. It represented the first time Judge Harrington had sided with Maya on a contested objection, a tacit acknowledgement that her legal reasoning was sound. As Maya guided Farrell through the final aspects of his testimony, she reflected on what had just transpired. Speaking truth to power carried risks, but sometimes it was the only way to clear a path for justice. She hadn't confronted Judge Harrington to win a personal battle, but to ensure her client received fair treatment in a system that too often denied it. The revelation had changed something fundamental in the proceedings. While Judge Harrington wasn't suddenly an ally, the overtly biased treatment had been checked by the exposure of their connection, and the implicit reminder that his own legal education had come, in part, from the very woman he had been treating with such condescension. Maya concluded her examination with a series of questions that left no doubt about Meridian's discriminatory practices. As she returned to her seat, Zoe passed her a note. "That was masterful. He never saw it coming." Judge Harrington cleared his throat, the sound amplified in the attentive courtroom. "We'll recess for lunch." His gavel struck with less force than usual. "Court will resume at 1:30. As he rose to leave, his eyes briefly met Maya's. In that fleeting moment of eye contact was a complex mixture of emotions, embarrassment certainly, but also something that might have been a reluctant respect. He quickly looked away and exited through his chamber doors. The gallery erupted in hushed conversations as Maya gathered her notes. The battle wasn't won. The case was far from over, but the playing field had been leveled. Sometimes, she reflected, justice required reminding those in power that they too had once been students, and perhaps still had something to learn. When court reconvened after recess, the atmosphere had transformed. Judge Harrington's posture was different, less imposing, more measured. His gaze no longer avoided Maya, but met hers with a complexity that acknowledged their shared history. "Dr. Richardson," he addressed her, the proper title now used without irony. "Your motion to admit the complete personnel records as evidence." Maya stood, preparing for another battle. "Yes, Your Honor." "Having reviewed the precedents cited," he continued, visibly working to maintain judicial composure despite his lingering embarrassment, "I find the motion has merit under Rule 803(6). He cleared his throat. "The records will be admitted in their entirety." Opposing counsel began to object, but Harrington raised his hand. "My ruling stands, Mr. Walsh." Maya nodded slightly, recognizing the significance. This wasn't merely a procedural victory. It was the judge actively correcting the course, making the fair decision that should have been automatic from the beginning. As Maya sat down, Zoe whispered, "We just won, didn't we?" "Not yet," Maya replied quietly. "But now we have a fair chance."